from Taylor's Law School, and I will be explaining the requirements of formalities and whether it detracts the freedom of landowners in dealing with property. Now, we will look into what exactly is formality. Generally, formalities are procedural mechanisms which are required to acquire a valid transaction. According to Critchley, a formality is a requirement that matters of substance must be put into a particular form in order to have a specified legal effect with sanctions of non-compliance. Therefore, for landowners who want to transfer, lease out, or write a will, he must fulfill many requirements of formalities. Section 2, Subsection 1 and Subsection 3 of the Land Property Miscellaneous Provisions Act stipulates that the contract for sale or disposition of any interest in land must be in writing, and that the document containing the terms of the transaction must be signed by or on behalf of each party to the contract. One advantage of this formality is that it can provide evidence that the landowner did enter into a transaction, as the writing requirement can guarantee evidence on the existence of a transaction, and it is durable, meaning it can be kept for a long time and used in any future claims and challenges to the rights of the parties in any potential dispute. Moreover, written agreements ensure that the evidence is credible and permanent in order to determine what the parties first agreed upon, as it is impossible to recall everything that had occurred during the initial agreement. The requirement of signing enables the courts to presume that the parties intend to be bound by the contractual obligation, because in the event of a court dispute, the judge would require more definitive proof of the specific transaction because they were not present during the events leading up to its creation. Therefore, formalities permanently record the parties' intention, which would be useful for resolving any future conflicts. In accordance with Section 52 Subsection 1 of the Law Property Act and Section 1 Subsection 3 of the LPMPA, there must be a deed signed by the individual in the presence of a witness who attests the signature, and it is delivered as a deed in order to have a legal validity. As it is difficult to get into the transaction in the first place, these procedures could prohibit the application of external pressure from outside parties. The requirement of conveyancing a land where the deed must be drawn out, signed in the presence of a witness with no interest in the transaction, and sent to the land registry will make it more difficult for other parties to continue the pressure, such as coercion or undue influence, and witnesses and lawyers would be able to detect these pressures. Thus, the execution of a deed and the presence of a witness would be able to attest that the document had not been tampered with, nor conducted with any form of pressure. Due to the numerous required formalities, landowners may become confused, especially if they are unfamiliar with the necessary requirements. Therefore, it would encourage them to seek legal assistance from lawyers to assist them with the transaction, where the lawyers would be able to provide advice on the effects of the proposed terms and explain the complexities in detail so that the landowners could make a fully informed decision as to whether the transactions are in their best interest. Therefore, these clauses demonstrate that formalities deter landowners from engaging in problematic transactions as opposed to allowing them to escape them later on. In addition, lawyers would be able to identify future disagreements and make appropriate arrangements for them, as well as clarifying both parties' objectives and additional questions or misunderstandings that may have existed. Hence, the requirements serve as a cautionary function if the landowner entered into a transaction without sufficient forethought and finality of purpose, and to give relevant advice. Next, the procedures surrounding the registration of rights will protect the landowner, as land rights are invisible. By guaranteeing that their rights appear on the register, prospective buyers will be able to see them. The registration makes available for public view the existence of the transaction, thereby protecting the parties' intentions. If registration was not required, landowners could be bound by transactions they did not intend to be bound by. Moreover, land registrations can lower transaction costs in terms of time and other resources spent, validating the ownership data as well as reducing uncertainty and land ownership conflicts. Additionally, according to Section 27, Subsection 1 of the Land Registration Act, Other parties may only acquire the right if appropriate registration conditions are met, making it obvious when rights are granted. Therefore, land registration will offer trustworthy information regarding the landowner's ownership of rights so that all purchasers are aware of the rights and interests associated with the land. Next, the channeling function specifies that the rules governing transaction will not have legal force unless they are embodied in a legal form that provides channels for the legally effective expression of purpose. The purpose of channeling is to describe how parties may employ formalities as a legal instrument to ensure a transaction has a legal effect. For instance, formality rules ensure that the proper forms are utilized after instructing lawyers to act on their behalf. Thus, it acknowledges the significance of form as a formal channel, signaling the parties' wish to be legally bound. Therefore, formalities reduce the possibility of unintentional transactions, prevent an unintended creation of land interest, and serve as a signal of the legally enforceable promise. Once the landowner has completed all formalities, they are free to decide what to do with their land, such as leasing it out. However, the demand for formalities has some adverse effects, as the failure to comply will result in the transaction failing and being rendered unenforceable, as can be seen in First Post Homes Limited and Johnson, where the intending buyer of land typed a letter to be signed by the vendor, which sets out the terms of the proposed sale and included the buyer's type name as addressee. The seller signed the letter by hand, but Lord Justice Peter Gibson held that the buyer's type name did not qualify as a signature for the purpose of Section 2, Subsection 3. Hence, the letter was not a binding contract. In most cases, non-compliance with formalities is the result of ignorance regarding the requirements of form or carelessness, which could be viewed as unjust and contrary to the party's intention at the time of the transaction. Parties may also fail to comply with form requirements due to the frequent misunderstandings, such as the sincere idea that upon marriage, separate properties becomes jointly owned, resulting in their failure to seek legal professionals. In such circumstances, it is considered unjustifiable to expect compliance with formality. Lastly, the stringent compliance would affect disadvantaged parts of society, such as the impoverished or parties who obtain subpar legal advice, particularly when the cost of compliance is high due to the necessity to pay legal professionals and land registry fees for registering a transaction. Moreover, the restrictive statutes diminish the personal autonomy of landowners as it regulates the behavior of landowners by preventing them from establishing an arrangement that satisfies their own needs. Even if they attempt to circumvent the law, they are still obligated by equitable rules. For instance, Section 53, Subsection 1 stipulates that interest in land must be created by a writing signed by the person if the person has a contractual obligation to transmit a legal estate to the land. Therefore, a signed writing is required if a landowner desires to provide another party a restrictive covenant, which is a type of equitable interest. In addition, the attempted formation or transfer of certain property rights will utterly be ineffectual in law or equity if the registrar is not appropriately updated. However, none of these disadvantages are particularly severe. Regarding informal transactions, the courts have evaluated several sections throughout time and determined that some rights are free from formalities since they frequently emerge in informal circumstances. In particular, Section 54, Subsection 2 specifies that leases of less than 3 years are exempted from formality as long as the substance requirements are met, as it is acceptable to be unaware of the necessity for registration. This type of exception allows us to preserve the party's intention, where imposing formalities could be counterproductive, as the transaction is likely to be conducted informally. Moreover, if formalities were effectively enforced, such misconceptions of law would be clarified and the formalities would no longer frustrate the party's wishes in this circumstance. Additionally, the issue with the fees associated with meeting formalities can be viewed as a minor deficiency as only some formalities entail cost, while others, such as requiring transactions to be in writing, does not. This cost of compliance will have a long-term advantage in that they will help avert future disputes, saving the landowner the expense of going to court and obtaining legal aid. Lastly, if the landowner executed a deed with non-compliance, equity can also assist them in these disputes. In Walsh and Lonsdale, a lease agreement of 7 years was executed. The tenant received a notice requesting payment of rent in advance, and claimed that he was not bound by the agreement because the lease was done without a deed. Justice Fry ruled that the landlord has the right to collect the rent in advance as stipulated in the lease as equity prevails. There is an agreement for lease under which possession was given. The tenant is treated as if the lease had been granted. Therefore, the disadvantages of formalities are not that significant and may even be advantageous to landowners as in the case of equity. Clearly, this implies that formality requirements are not devoid of downsides. However, the landowner would realize that the benefits of using formalities vastly exceeds the drawbacks. In addition, the necessity of formalities will increase the possibility that parties will sign contract in the presence of their lawyers to provide clarity, and these procedures would enhance protection and information accessibility, hence eliminating doubt over their land rights. Therefore, the legal system of formalities limits the freedom of landowners to some degree, but only to ensure that landowners take the process of transaction seriously to protect themselves from the influence of malfeasance, provide clear evidence of their intent to transfer, and execute documents that courts can easily identify. In conclusion, despite that it is troublesome for landowners, the formalities work as a legal framework to guard any perplexities. Thus, it does not defeat the landowner's autonomy rights, but to protect him in a variety of situations. They certainly could, on balance, do more good than harm. That's all from me. Thank you!